Good afternoon. Welcome to the Rules and City Government Committee. Please note for the record, committee members Alderman Arnett and Alderman Savage are in attendance, along with City Manager Gerald, Planning and Zoning Director Dr. Nash, Public Works Director Mr. Johnson, City Attorney Mr. Lyles, and we've been joined by Alderman Gay. And I think that would be it. I'll entertain a motion to approve the agenda as written.
So moved.
Second.
Okay, all in favor of approving the agenda as written, please say aye.
Aye.
Okay, next item is approval of the minutes from the March 2nd meeting.
Move approval.
Second.
All in favor of approving the minutes as written, please say aye.
Aye.
Aye. Okay, thank you. First legislative item on our agenda is 0621, agency regulations, for the purpose of establishing a procedure for the adoption of regulations by a City of Annapolis, department, board, or commission, requiring public notice, providing an appeal process, and generally relating to City of Annapolis regulations. Alderman Arnett, this is your legislation. We've already, I think, and Ms. Green can assist us, have we already voted on the 10 amendments, the Arnett, Savage, and Finlayson amendments?
No.
I don't believe we have.
No.
Okay. Okay, so Alderman Arnett, will you do us the honor in reviewing these 10 amendments?
Yeah, so by way of brief background, this is a revision to Title II of the City Code, which currently prohibits the issuance of rules and regulations by departments. I submitted a piece of legislation that addressed that, and then the Office of Law, which are these amendments that we've seen, the Savage-Arnett amendments, worked on cleaning that up. And that's where we left this at the last meeting. Mr. Lyles promised and gave us a turnaround of one day, a set of amendments, all of which I both appreciate and subscribe to, that clear up a lot of the things that we were discussing at the last meeting, clear up a lot of the ambiguities that were in the legislation. And I think we're at the point of considering those amendments, 1 through 10, is it? Yes, 1 through 10, which are significant, but I think are also more in the realm of editorial changes to make things both clear and legal. And unless there is concern by other members of the committee, I would move that we accept the 10 amendments in their entirety to change the legislation as submitted on first reader.
Alderman, may we ask Attorney Lyles to kind of review these amendments, or unless you'd like to do it, and particularly as it relates to definitions, or because I think looking just at the first one, and I think several throughout speak to use of the term promulgation instead of adoption, for example.
Yeah, thank you, Madam Alderperson. Basically, these are not technically substantive changes to the bill, but clarity was necessary because in the code, adoption versus amendment means certain things that the code's already established. And so with regulations, since they're different than codification of your desires, I submit that promulgation is a better word. It's just how you proceed to put this on paper, and to not have it confused with adoption, amendment, which you normally do with the charter and the code. So that's really why I suggested that. The other things have to do with just clarifying language with respect to how, like in Amendment 2, drafting, review, and publication, because there was an issue with the document being published. And so I was just kind of making the words fit what the intent was there. And executive department, board, or commission using the words that the code uses to clarify. And then promulgated and published is kind of what I did throughout. Amendment 6, a newspaper of general circulation in the city, just to clarify that regulation could be put in any paper. What we're finding is that when we do something in the Gazette, it costs $1 gazillion. It costs a lot of money. And so there may be other newspapers of general circulation that may be less expensive, since what we know about regulations right now is that there are a lot of them. And if they're changing on a regular basis, that's a lot of money if you're going to just use the Gazette. There may be others, don't know, but if there are others, this would be an all-inclusive. Let me see. And then everything else is just kind of clarifying language. No real change to the intent or the substance of the provisions, just cleaning up the language so that it's clear.
So if you'll recall, as I said earlier, for some reason back in 2006, the City Council passed an amendment to Title II that said that departments can't write rules. That's obviously not desirable. On the other hand, what I wanted was that the City Council and the public be aware when rules are being written, rules are being made. It gives us time to review the rules and comment on them. The departments can take those rules under advisement. Ultimately, the power still rests with the council. If there's a rule that is promulgated or published that we find has some deficiency, we can, through legislation, through ordinance, change the parameters. So right now, this would allow departments to do things as simple as issuing application forms. That's a form of a rule. Some of those come with fees and so on. And as City Manager Gerald can talk to us about, when we started to look at all the rules and the city has, turns out there's an unknown number, but are potentially significant. And so what I was looking to accomplish with this legislation is that we know about all the rules we have, and in here we create a repository of all the existing rules. We know when there are new rules being made. We are part of that process, at least to the extent that, like the rest of the public, we're made aware of the rulemaking, and we can comment on the rulemaking if, and I would say this is not particularly likely, but if for some reason we find as a body, the majority of us, that the rule has some deficiency or unintended consequence, we can always dictate through legislation that that rule be amended, and it'll go back into the whole rulemaking process. A lot of the comment that led up to this in discussions, particularly with the city attorney, Joel and I, and also city attorney Lyles, was that, rulemaking is something that is much more operational usually than code. So code sets forth the policy and even broad procedures, but it is the rulemaking at the operational level, at the staff level, that is how the code is implemented. And I think from my perspective, the staff are the people who are closest to that. They're the ones that know what they need in order to properly implement the city code. And I think they're the appropriate level to promulgate rules. And all I wanted was that everybody, including the council, know when that's happening and have an opportunity to read and comment on it. And I think with these changes from the city attorney, we're there. I did send to you some comments from Mr. Conlon that get into some things that are more procedural, like designating a person who's responsible for the keeper of the rules. I think we can leave that up to the city manager and how that's done. Mr. Conlon points out that promulgation is actually the publication of rules, and it's the rules themselves that are the substance. I take his point. I think he's correct, but I'm not sure how much we need to get into legislating that clarification. So Mr. Conlon went to considerable effort to look at what was in the revised code, made a number of specific comments on it. I forwarded that to you. There's 4 major areas of comments. And certainly, Madam Chair, if we want to get into discussion of those points, I think that would certainly be a worthy effort on our part. But
Alderman, are you proposing his recommendations as amendments from you?
I am not at this point. No, I think we have quite enough changes, and I think that these are things that we can always come back and let's put this system in place, try it out, see how it works. We may need to come back and do some tweaks, and these could be some tweaks that we find we need. But I think the legislation is pretty much where it needs to be at this point, and I'm ready to move it on. But I wasn't ready. I was ready until Mr. Gerald raised his hand. Now I'm not.
I was about to ask Mr. Gerald, but before I do, may I ask Mr. Lyles, or maybe it's a question for you, Alderman Arnett. You added notification by newspaper. Would the city website be not as appropriate location to announce changes?
I think
as opposed to an expense of putting each one in the newspaper.
So we go to that expense to announce plans for development, really all of the major ones. And I think changing rules has every bit the weight of a major site development. I know it's an expense and it also takes time. And one of the points that the city attorney made, and I am in sympathy with that, is that we want a system that is much more flexible and much more expeditious. Otherwise, we do everything by ordinance and we go through the whole process we do with ordinances. But these rules, as I said earlier, come with things that require constituents or applicants or developers to fill out. They come with fees and fines in some cases. And so I think they are significant. I don't think we should take them lightly. And I don't think promulgating new rules or changing old rules should be taken lightly. I think that it's important to let people know. It's how the federal government does it through the Federal Register. And they publish it, they invite comments, they respond to comments, and then they promulgate the rule. And I think that letting people know, assuming that people are going to the city's website every day or that they're going to the Capitol every day and reading that legal section is probably a strong assumption. And probably the people who will be most sensitive to rulemaking will be the city council, because we will get direct notification of it. But I do think that rulemaking is an important part of city operations.
Thank you. Alderman Savage, I'm going to ask City Manager Gerald to weigh in on this, and then I'll call you next.
Yeah, thank you, Chairwoman. So I just wanted to offer up, at the last meeting, we talked about the fact that we were surveying all of the departments to try and figure out how many regulations there are out there. And honestly, we didn't know if there were 100 or 3. We just had no idea how many there were. It turns out there's 1. That's all we could find was 1. And that's the Aqua Public Facilities regulations that were issued by Planning and Zoning. I can tell you from my experience in public works, we didn't do any in my time. And I guess since 2006, they were kind of prohibited, so they weren't done. But that being said, there is a need to do some. I mean, that's what we have found out. For instance, when the council passed the resolution on stormwater management, increasing the percentage, I really should have issued a regulation to implement that. But instead, I issued a implementing memorandum that gave direction to the staff to implement those numbers. That should have been a regulation or a rule or a regulation. But over these last years, the departments didn't really know about these, and they were prohibited anyway. So they weren't done. Park and Rec has a number that they should do. I mean, they have informal rules like leashes in parks, right? That are very informal, but they probably should be formal rules. So we're going to look at those areas and start to try and tighten up now that we can start issuing them again, to issue those that should be as rules and regulations. Just like I said, just to tighten things up a bit.
So, Mr. Gerald, that's exactly what I was getting to with the cost of advertising in the newspaper. If we have 1, then that's a different story than if we have 50 or 100. And it sounds like we're going to have more. So I just want us to be cognizant of that fact, that there may be an increase because there are some things that should be promulgated in our code. So just an awareness. And if it comes to the finance issue, we have to remember that we've added an additional expense that, I'm not going to say maybe we could have dealt with in a different way, but I don't know, maybe. Alderman Savage.
Thank you, Madam Chair. And thank you, City Manager Gerald. That's helpful to know. But I guess maybe it's worth more discussion about what we're considering internal regulations, because I think in some regards, although I think these are already handled elsewhere, but in some regards, the Forest Conservation Act, the technical manual and the stormwater management manual, and probably even the sediment control manual would be, well, I don't know, would they be considered regulation? Because that's, I think they're put together and often are treated as regulation and are used as guidance when implementing the policies that are written into the code. They provide a lot of the detail and the meat to those programs. I mean, I know, just as an example, that something I put together, 15 years ago, was like a integrated pest management policy, and that wasn't something that the council adopted, but that was just something that I think the city manager at the time had taken on and just was using for from the environmental director in terms of guidance to the rec and parks and some other things, other departments. But I mean, that's all really I can think of off the top of my head that might have regulations already. But the fact that we only have one that you can think of now, I think, like the chairwoman said, it helps me, I guess, to understand more about the potential cost of this in terms of getting something posted in the newspaper. I really do think that posting a notice in the paper is really, I think, essential in my view, because I think it's the best way to notify the public, people, I know less people read the newspaper, but those who really want to be informed do read it. And I think they do pay attention to these notices in there. A lot more people read the paper than I think watch our meetings or are staying tuned to our website. I've been told by the paper that it would cost a couple $100 to post a notice. Granted, it was more than I thought, but in any case, if we're just talking about a few regulations, I think it's something that I would hope would certainly be manageable. And if it does end up being a high burden, we could certainly revisit that. And I also don't want that to be a burden on any department, nor do I think it should. And also, City Manager, just to let you know, I know we talked last time about the public comment process, and I think this was mentioned a little bit already, but just to clarify, the one amendment from the law office, which the committee talked about last time, I think was Amendment 7, and it does remove on page 2, the item C, which had required departments to have an additional public hearing on this, which we talked about last time. Some of us felt was a bit burdensome, and I think you had alluded to that as well. So that's been removed, and if I'm reading this correctly, Mr. Miles, please correct if I'm wrong, but the way I'm reading it is that it would leave it up to the council committee to request a public hearing, presumably at one of our committee meetings.
Yep.
And so that, I thought that would work out well, because then staff doesn't want to have to go through the whole rigmarole of having a public hearing, and since the council will be discussing it anyway at committee. So that's it. I think this is a good move. I support all the amendments, and yeah, I'm good to go.
Alderman Arnett?
I guess I'm shocked, and I am now concerned about what we're viewing as rules. For example, the harbor master alone has a ton of rules. There are rules about the size of the engine that can be on a dinghy that ties up at the headwaters at City Dock. I consider that to be a rule, and she is prohibiting people from tying up if they have an engine that is more than 90 horsepower, and finding people that she finds them there with an engine more than 90 horsepower. So I am now really uneasy about what definition we're using for rules. And I'll go further. I hearken back to the whole discussion about adequate public facilities and about how much was in the adequate public facilities legislation that it was viewed should not be in code, but should go into rules. And so clearly there's an intent that those be rules. The whole cast of the conversation at that point was there were too many things in the city code that really should be rules or regulations, not code. And so I guess I'm flabbergasted that you find one rule. I agree with Alderman Savage. There are all kinds of rules about doing the management of stormwater runoff and there all of the other environmental kinds of rules. And I think there are rules about meeting the statutes for building code, for meeting fire safety and so forth. Those are in the code now, but I had every sense that it was the intent that those would come out of code. The fact that we adopt the APF, the NFPA for fire, and we adopt all of these building standards. And it was my sense that those were coming out of code and going into rules and regulations. If that's not what we're doing, maybe I wasted a lot of time putting this legislation up. I would never have done it if I thought there was only one rule in the entire city, or one thing being defined as a rule.
Mr. Gerald, and thank you for using your raised hand symbol. I saw you.
Thank you.
And then Alderman Gay will be next after you.
Yes. So the way we define these was, number one, it has to affect the public and not just be internal. So we have a lot of rules and regulations for city employees. And I think the integrated pest management policy that Alderman Savage was talking about would be more internal, because that was providing direction to each of the departments on what pesticides that they could use. So we didn't count those. I think that there's a lot of informal rules that are applied as if they were, rules that were issued in accordance with the code section. So that's why I think that we need to clean this up and make sure that those that do exist are properly issued. And Alderman Arnett, as you said, that we've been prohibited from issuing those since 2006. So I think nobody has done them, and so it's just been an informal process of issuing these sort of rules and regulations that need to be in place to guide the operations like Harbor Master, but couldn't be done through the formal regulation process.
Okay, that makes me feel better. It is your sense that there are some things that have been informal all along that need to be formalized. And I agree with your internal versus external. My concern was rules that affected residents or businesses and oftentimes come with obligations to fill out forms, sometimes come with fees and or fines and those sorts of things. And those definitely have an external impact.
Alderman Gay and then Alderman Savage.
Thanks, Madam Chair. I have a few questions. One, I'm not seeing in the legislative text any, because I was trying to find where it stated the publication in a newspaper. Where does it say that at?
It's in amendment number 6. It's an amendment.
So let me just read the amendment before I really quickly. I'm sorry, because I was. Yeah, I guess my question then to that would be, could I post it on Facebook through a blog, which is technically like news, that is considered news, and publicate? I just am worried about that. And then I had a question as it related to the time period that you put in between in the actual. Let me just pull it up again, the actual legislative text. There were 2 meetings in between the actual adoption of any policy. And then you also stated that a review should be done every 5 years. And I was just, considering the concern for, keeping track of the rules and making sure that the staff is actually following through. Should the review period be shorter than 5 years? That seems excessive. And administration could change in between the review periods.
Well, actually, that's why I made it.
Before we go to your second question, I should ask City Attorney Lyle if Facebook and electronic social media would suffice for newspaper, because clearly the amendment speaks to newspaper of general circulation.
Well, those are substantive draftings by the sponsor, and I have no comment one way or the other about that. The intent behind the drafting, the language that we received was newspapers. So if there's something different than newspapers, that would have to be answered by the sponsor.
Okay, Alderman Arnett.
No, I think the thought was newspaper. I think Alderman Savage and I have both discussed that. And I think that is considered, and I'll leave this to the city attorney, the legal notice, just like the newspaper is full of all kinds of legal notices. So but I'm old school. I don't use Facebook to want.
Well, it just says a newspaper of general circulation in the city. That could mean anything. A newspaper, it does not have to, when you refer to, I get the Capital Gazette on my phone too, just like the Baltimore Sun and all of these other things. So it doesn't have to be a physical newspaper. It could be some form of electronic image distributed on the web. So I just think that amendment number 6 could raise an issue.
Clearly it has with you.
Alderman Arnett, did you answer the second part of his question?
Yeah, the reason I put 5 years is, first of all, I was thinking there was a much greater volume, and I still do think, but I intentionally made it 5 years so that it isn't coincident with change in administration, or it will be every 24th iteration, because I didn't want to have a situation where a new administration comes in and makes wholesale changes in the rules. But really, this is just a review. It says we need to go back. Clearly, we certainly haven't reviewed regulations since 2006. That's too long a time. And I think that there should be a periodic review. I think that review will be done by the departments. It's not going to be done, each department is not going to be done by us, and they'll just review their regulations, say, oh gosh, the state law has changed. We need to fix that one, or this one is no longer relevant. So it's more of a housekeeping function. Let's just make sure that all of our rules are up to date and relevant.
Yeah. And then, Madam Chair, I just have one last question, actually for the city manager. So if there are no, and I may have heard you incorrectly, but this is just what I heard. There are no official rules except for one rule or regulation. Everything else is an informal direction. And so if a staff member goes against the informal direction, could they be disciplined appropriately? Technically, they're not breaking any formal rule or any city code. It's a verbal, direction.
Yeah, so again, what we're talking about with these regulations is the outward facing ones that affect the public. We have rules and regulations that are in effect for our employees, both departmental and as a city as a whole, and those all apply, and those were properly issued. It's really these other ones, like the fact that you need to have your dog on a leash in a park, right? So that's an informal rule that Rec and Park has, is that people have to have their dog on a leash. That was never issued through this code section on how regulations are supposed to be issued. So we need to gather up all of those. And I mentioned the stormwater management as well. I think that's one that really should be a regulation, because that's what developers have to meet, is those percentages of treatment. So we need to gather all of those up and issue them properly through this regulation process.
Thank you. Alderman Savage.
Thank you, Madam Chair. To Alderman Gay, the intention certainly is just to have the notice be in the newspaper. I hadn't really thought too much about Facebook, but the challenge with that is that with Facebook, you don't even really necessarily know who it goes to with all of their, proprietary algorithms in terms of who sees your post. So I don't know if that would necessarily be sufficient. I think it'd be a good idea to do anyway, but I think to meet an official notice, what I was thinking is just the newspaper. So yeah, I think I would like to change that Amendment 6 to read the Capital Gazette. If we just strike a newspaper of general circulation in the city and put the Capital Gazette, then I think that'll clear up, to Alderman Gay's point. And we only have one newspaper of printed, a traditional newspaper in the city. We have various online blogs and like the Patriot and things like that. But I don't even know if they have a section for these kind of notices. But again, the reach would be of a concern to me. So I guess if that's one thing I'd ask the chair how to proceed in that regard, if we could change that to.
Well, that would be a motion, and I would second it. Although
Mr. Arnett, could you wait one moment? These amendments have not officially been introduced or seconded as amendments from the three of us. And that was my initial question, whether we had voted on them, because they're labeled as amendments from the three of us. So we have not yet voted on them at all. So I think we can change it now. So if you'd like to change that particular one, if we want to deal with all 10 of them at the same time. If not, if you want to take them separately, that's another action we can take.
Okay. And Madam Chair, if I could ask one more question just for the city manager. So I think I'm starting to understand the distinction that you have stated about public versus internal. Although I think sometimes it's going to be tricky in terms of the line is not always going to be too clear. But I think some other things I've thought about that might be considered regulation would be the site design manual that we use for site design review. There's a lot in there. We just passed the small cell regulations that Dr. Nash put together. So they might be considered, although they really, well, I mean, I guess they impact the companies, not so much the public, but site design certainly impacts the public. But also, you know, all the general orders for the police, you know, some of those are internal, but a lot of those do have a direct, obviously, impact on the public. And I do think it's good to give some transparency to that process and that department. I think that'd be good for both the public and the police department. And the council, frankly, to know when there are changes to those general orders that they need to be brought to the council to at least make us aware, because that's one of my fears is that, you know, those general orders can be changed on a whim based on a new chief. And I think, so I don't know, what would do you think the general orders may be considered regulations under this?
Are you directing your question to Mr. Gerald or Mr. Lyles?
Whoever has an answer, I guess.
I saw Mr. Lyles' hand up, but I see Mr. Gerald's mic is off, or on.
Yeah, if the city attorney wants to address it first, then I can piggyback on his thoughts.
Yes. What we have crafted here with the sponsors is clear language as to what a regulation is. The topics you're bringing up now are not regulations because they do not control, dictate, or mandate what the public does. A lot of what you talked about with the small cells, you've already codified. So there's no need for regulation, which is part of the issue that we've talked about. There's so much in code that's like a regulation that we haven't needed the kind of detailed regulations that we're now kind of facing should be in vogue in the city. With respect to the general orders, it's not appropriate to call them regulations because they're not those. They do not mandate that the public do anything with respect to what you shall do or what's prohibited. And the general orders don't get changed on a whim. General orders are police internal policies and procedures that derive from several sources. There is a accrediting body that accredits police agencies. The city of Annapolis has an accreditation with this national body, and general orders have to go to that accrediting body in order to get the city of Annapolis Police Department accredited. Additionally, the International Association of Chiefs of Police also have an impact on how those general orders are developed. Just like with DPW or planning, overarching national and international standards dictate what an internal policy or procedure may look like. And none of those that I know of are done haphazardly because they do have to flow up to larger bodies to be approved and accredited. And a lot of organizations like ours are part of those organizations.
Mr. Gerald?
Yeah, I was just going to answer the first part of Alderman Savage's questions about some of the developmental rules and requirements. I think possibly those definitely affect developers and place requirements on them. So those would be some that we would look at to see what we need to issue as far as regulations go for those.
Okay, yeah, and I guess I'm just trying to understand this more in my mind, because if you know, I'd like to hear from the sponsor again, Madam Chair, if you have the opportunity, just because I'm curious what his intent, because I know when I signed on, I think I signed on to this. When I signed on to this, the idea I had was to kind of, I think, get some of the internal policies as well to be made public, because, you know, I think part of the interest is yes, we want the public to be aware of things that are going to impact them. But I think the other part of it is, I think the council wanted to be made aware of regulations or internal policies that are implemented, that in turn are implement our legislation. You know, we want to make sure our legislation, our policies are properly enacted, and to be able to at least see some of those internal policies or things that are adopted. So for example, if we did pass, something saying we wanted the city to adopt a integrated pest management policy, and then that was drafted internally, you know, I think that would, because that even that, it's not directly going to impact the public, but it is going to, you know, if they visit our parks or things, they're going to be impacted by the pesticides, just like with the general orders, those governing searches and seizures, that's going to be, that governs how the police do that, but that's going to have a direct impact on the public, because that clearly shows what procedures the police are going to follow in terms of when they do search somebody and under what pretense. And it does actually say, for example, under domestic violence, it talks about how they're supposed to be guiding victims, treating them, guiding them to treatment, making them aware of treatment options, that kind of thing, which is all well and good. But again, I think the council, if you're saying a lot of these things are set in stone, I think kind of says, what's the council's role in all this? Because when I was doing research on some of the police general orders, that other jurisdictions have kind of done the similar thing like they did with the state. You know, they pass legislation that says, we want you to pass internal regulations that include at least a minimum X, Y, and Z standards. You know, the details are up to you, but we have these certain standards, kind of like what the state does when they pass statutes that have minimums, and then the state expands upon that to create these huge regulatory manuals like for forest conservation. So I'm still not quite clear on that, but I'll
Mr. Lyles and then Alderman Arnett.
Yeah, I guess you could call anything a regulation, but what you have to try to do is remember that you want to, for clarity's sake, put everything in its box. To the extent that you don't do that, there will be a lot of confusion. Normally what happens when we term these kinds of things regulations, we're trying to regulate the public, not as it relates to just being the government, but as to each other, right? So you couldn't park your car on a curb 5 feet from the curb. Now, that doesn't have anything to do with the government. That has to do with how you drive your car and deal with other people. So the regulations are the detail in the standards that you've provided. When it comes to employees and internal processes, some of that could be called regulation, but more policies and procedures at this point than regulation. Again, just to clarify, not as much to limit your authority, but the charter limits your authority with respect to how detailed you can get in the executive functions. And to the extent that the council doesn't hire anybody, the council can't fire anybody, you also can have as detailed control over the in particular detail of a person's hiring and firing. So you can set the broad policies all day long, and it then is on the city manager to then put policies, procedures in place to deal with the overarching policy. That's how the council affects its desires. If the council were to do anything more detailed than that, you would then be in the executive function, and the charter right now prohibits that kind of activity by the legislative body.
Thank you. Alderman Arnett, and then
So I have some pretty fundamental disagreements with that statement, but I think, Rob, you raise an interesting hybrid. So I agree with the city attorney. We need to try to put things in the right box, but clearly there are things that can be properly put in more than one box. And certainly the general orders definitely are internal rules, but they also affect the external populace, and they are policy issues. So I think it's totally within the prerogative of the city council to say it is the policy of the city of Annapolis that police officers don't kneel on people's necks. That's a huge policy area. It definitely affects the people being policed. It definitely sets a standard that we expect to be adhered to. So, I think you raise a very interesting dilemma, and I don't know that we're ever going to have agreement or properly draw those lines, but I totally argue that there are only 9 policymakers per the charter, and it's the elected officials, and the elected officials can make the policies that they think are appropriate for the governance and the maintenance of the city of Annapolis. And I think we're inevitably going to get at, where's this barrier? Where is someone stepping on someone else's toes? And I think those are things that are just going to have to be thrashed out as we come to them. I think we'll have a lot of interesting discussion as the peace initiatives finally make it to legislation to discuss where those lines are drawn. But I'm perfectly willing to accept that there are rules and procedures that are for the internal governance of city employees, and that largely does not affect the public. And if we say it's not appropriate for city employees to spit on people when they come to file an application at Parks and Recs or Public Works, I think, but that's kind of twisting in an extreme. So I can accept that one of the paradigms would be that these are regulations and rules that we're interested here are the things that affect the general public, the things like the size of the engine on a dinghy, or the fee that you have to pay to fill out an application to appeal a decision. All of those things do affect the public. They're also part of internal operations. And I think there's always going to be ambiguities there.
Thank you. I think Alderman Gay, and then Mr. Lyles, are you responding to what Alderman Arnett just said?
Yes.
Okay, Alderman Gay, please be patient.
Yeah, the words in this particular realm, the words matter. Everything you do affects the public. Regulations restrict or mandate citizen activity. So affect is the broader word, but what we're talking about with regulations is to restrict a citizen's activity or to mandate an activity. And that's really what we're talking about with regulations.
I agree with you. I think it is true that we can argue, given our educational background, Mr. Lyles, we can argue the number of angels on the head of a pin, and where there's always going to be those gray areas. But I generally subscribe to what you're saying and what City Manager Gerald said. What we're really looking at here are the things that are going to affect and not just residents, but anyone who does business with the city or visits the city. It's things that affect them as they go about their business in the city. And we're not interested in things you have to do to get a step increase in promotion. Those are certainly internal and definitely administrative in nature. So, I think that Alderman Savage raises an interesting situation that we'll get to when we start looking at the peace initiatives. And we're probably going to have some tug of wars there, but that's why we have elected officials.
Alderman Gay?
Thanks. Yeah, I just had some, just points of clarification. Technically, can't not individual staff members, but the city council can fire by taking a vote of no confidence, correct?
Only the city manager.
So
Vote of no confidence does not trigger a firing of any sort. I mean, it might trigger, but it doesn't promulgate it.
okay, and I think that is part of it then to the conversation that I have sometimes with you, Ross. What are we here for? Like, we can't and just because I feel like there are so many restrictions, and to the point that the city attorney was making and saying that we can't direct staff there's just so many regulations and guidelines into even how we can communicate with staff. Part of the problem is that we create these policies and procedures, and because we can't follow through on them, they don't get done. And so it's like we're ineffective in a way. I mean, we make the policy, it's supposed to be followed through on by staff through the direction of the city manager. And that, I mean, so where do we have, leverage to say, okay, this is what the city council has voted on and agreed upon. It's an ordinance, make it happen. Where is that accountability at?
So the city attorney didn't say that we couldn't speak or direct the staff. The code did, and we wrote that. And we wrote it in response to a specific council member who was overstepping the boundaries of the city, at that time, city administrator, and going in and telling various staff members or various department heads, I want this done, I want that done. And first of all, it disrupted their normal flow of business and so forth. Our power comes from setting policy goals. It's very clearly expressed in the charter. And we would have chaos if all 9 of us were going to Sean Wampler, for example, and saying, I want this GIS project done because I need it for tomorrow. You just can't have that. And that's why we have the city manager as the proper conduit, so that anytime I ask for something, I always address it through David, through the department head. I just recently asked Sean for something, and the email went to David, to Brian Paquin, and then to Sean, saying, could you help us with such and such? And it went back up through, and I had a very, very direct conversation with Brian saying, I've got Sean working on another big project now that's taking up a lot of her time. Can you wait 2 weeks? Which, of course, I could. And not only that, if I couldn't, it's too bad. I had to. But, you have to have rules that allow for a proper flow of business and proper channels of communication. And in our system of government, we've designated that as the city manager. The mayor is the chief executive officer. The mayor can sign lawsuits of petroleum industry and opioid dealers and big contracts and small contracts, because that's clearly designated in the charter. And it's what we can do are the things that are in this and for the charter. So we make policy, and we have general powers and duties. The council shall be the legislative body. The powers and duties of the council are to conduct oversight of expenditure of public policy and delivery of municipal services. Now that last one can be very broad.
I think I don't know if you've answered my question. You've clarified some things, but my question still is that if the council creates policy, who then is to hold the individual staff accountable for the policy created by the council? Because in my short time of being here, I don't know about you, but in my short time, 2.5 years, I don't see that accountability. And I could see how rules and regulations are misinterpreted, or, there's just it's a lot. Like, so where does that accountability lie? And is that something that if you're are creating legislation designed to help with rules and regulations that could be, accomplished in this legislation.
Alderman Gay, I think there needs to be a further discussion about the role of the council and the role of the city manager and the role of the mayor. Too often we do pass legislation and we do not give the appropriate staff to handle what we've asked staff to do, whether we haven't funded it. And in many cases, that is the problem, but we have not. And so that falls on us. If we ask staff, or I want a stronger word, can't come up with it, but if we pass legislation and then we don't give them the tools they need to accomplish it, and we have to empower staff through our city manager to come back to us before we pass it to say, if you want us to do this, these are the things that we need, okay? That falls to us to accomplish. It is not the city manager's responsibility. I mean, he does tell us, and that's why he's on this call, to tell us what's doable with this piece of legislation and the next. And he then goes back to direct staff. But if we don't give them the tools they need to accomplish the task, that falls on us. And we need to fix that about us. So may I call on Alderman Savage?
Thank you, Madam Chair. And yes, I do agree with you. I think personally, I in no way wanted to put any kind of blame on staff. I think we burden them with a lot of duties, and I think things can just, I think the council's intention can sometimes get lost or misinterpreted, or plenty of times our laws are just not as clear as we think they are. And I think regardless, I think us getting notified of these regulations will help us to say, okay, clearly that wasn't what we intended, or we need to improve here and there. So I think this will hopefully help all parties involved, including staff. But I also do want to say to city attorney's comments, I do think, the separation of powers it's not described anywhere in the charter. I think it's implied with a number of comments in there in terms of, the council being policymakers and how the council can't direct staff. I think that implies a lot, but I think one area where the charter is quite clear is in terms of the council's abilities when it comes to passing laws. I mean, in the charter section 2, it says the city council shall have the authority to enact all laws necessary for the proper functioning of the government and of the city and for enforcement of these laws. That is pretty darn broad, but I also think pretty specific that we do have that ability. That doesn't mention anything regarding the separation of powers, but I do think that I think tells me that we do have the ability to pass a lot of these laws that speak to some of these standards we'd like to see in any of the regulations. But, I'm sure Alderman Arnett and I, and perhaps some of the others could probably be here all afternoon debating you on this. But for the sake of moving forward, I guess, Madam Chair, I think
entertain a motion.
Yeah, so the discussion I think is good, but like you said yourself, we don't necessarily have to have it right now. So I would move that I would move for adoption of amendments 1 through 10, with the exception of 6, which I'm going to change to have Capital Gazette. So actually, maybe I'll just move them all, 1 through 10, but change 6 to strike a newspaper of general circulation in the city and substitute that with the Capital Gazette newspaper.
I second that motion.
Okay, further discussion. Alderman Lyles, and I'm sorry, Mr. Lyles, sorry. And,
Madam Chair, I think rather than adoption, that's a recommend favorably from the committee.
Yeah, so I'll recommend favorably 1 through 10 with 6 changed as I mentioned. And I think making Mr. Lyles an alderman would be challenge to the separation of powers.
He's been there and done that.
Been there, done that. Thank you.
Right.
Alderman Gett.
Give me the city attorney pay.
Get your degrees and you're on it. I'm telling you.
It's not what you make, it's what you keep.
Oh, okay. Amen.
I like that.
Yeah, I do too. For just quickly, I had two quick points. The first, I can't find it. Where is that in the code? Does it say that the staff can't direct, or the city, the older people can't direct staff? I thought this was something that was done in like the 1900s. This is something more recent, you're telling me. And I'd like to look into repealing it because I think it creates a number of issues. I can't find it though anywhere in here. I'm looking.
I think it's in Title 2.
Section 2A.
Okay. And then secondly, to the point of the amendments on the floor, I would be even concerned with, and I'm obviously not a member of this committee, I'm just voicing opinion as a member of the council. Even with putting the Capital Gazette in print, in verb, I don't know. I think that a request requiring a publication in a newspaper just is outdated, you know? And so I think that it would just be a waste of financial resources for whomever would have to contribute the resources to have it published. I think the website would be just fine, and maybe a requirement to have it placed on the city's social media pages as well, so it can have a broader reach. I just think the newspaper is just a little, you know.
Well, let me ask Mr. Lyles. I understand where you're coming from, Alderman. We are a little bit outdated in that we still read a physical newspaper, and that many people get all of their news and information from social media. There's got to be some legal justification or coverage for us if we said put this information on social media, because that, in my mind, limits the reach, whereas the Capitol is presumed to reach a broader, and maybe not a broader, but do you understand what I'm saying? Do we have a recourse? Is there another reliable source that would speak to social media or other media other than a physical newspaper?
That's really a management issue because it's technical in nature. I know that our website has social media connections. So you can download the apps and things for the City of Annapolis website, just like you can for the Capital Gazette. And that is potentially social media. But I think the city would have to adopt social media pages, Instagram, Facebook, all the big ones at least. And the city is doing the publication. And so the city would have to have a page in order to publish those on. I think the website allows for that kind of cross-pollination of social media, but that's really a technical question, not a legal question. But the way that we drafted it was so that it's not limiting. We can do all of the above, but we at least need to do the two things that were required in the verbiage, and that is website and newspaper, or website and now Gazette if the motion passes.
I am not seeing, and maybe it's not in the amendment because that's the page I'm looking at, where it speaks to social media. Does it speak?
I think again, this is a management issue because now you're putting another requirement for publication that requires resources that I can't speak to.
Okay, I'm referring to social media that you just referenced, like the city's Facebook page or the city's whatever other social media.
Yeah, those are technical. I can't. I couldn't answer those questions. It's an IT question.
Alderman Savage, I think you had your hand up.
Well, yeah, thank you, Madam Chair. Just that, I think based on observations from my constituents, I think a lot more people, a wider variety of people read the paper than I've seen simply use online media. But I do think it's a debate for another time in terms of the state of media today. I don't think social media doesn't have the same checks and balances or quality that I think printed media does. We saw that with the previous election in terms of all the misinformation that was spread. So I don't think those entities with their, again, private algorithms that dictate who sees what should be used. The newspaper's been around for hundreds of years. It's proven in terms of its effectiveness in getting the message out. I think, at least, that's my intention. I think, I'd certainly be open to adding things in there about social media, but I do think as a bare minimum, the newspaper, that's where I'm coming from.
Well, let me ask the committee members, because what rang in my head was the cost of putting this in a number of newspapers, thinking initially that there were lots of these items that would need to be advertised. So would there be a problem with saying on newspapers, and I like the general circulation in the city, because right now we really only have one, and its circulation probably has been cut in half since I've been sitting on the council. So they do not reach the largest proportion of our residents, but they do now online newspapers. And I would gather that the number of people who are getting the papers online has increased substantially. So are we addressing, or can we address by simply saying and forms of social media to which the city subscribes? Which means that the city would have to have the Facebook or the YouTube that we do have, or any other media, social media platforms. So Alderman Savage and Alderman Arnett, what do you think?
I think it's time to call the question and move on. I think we can let that resolve itself as we put this into practice. I'm comfortable with it being in the newspaper. If the city wants to put it other places as well, I trust their judgment.
Well, Mr. Lyles, can we still put it in other locations without adding it to this?
You may.
Okay, then I'm good with it then. Okay, so I think I heard someone call the question.
Well, I suggested we should.
Okay, then you should make that official.
I think I'm ready to vote on the amendments that we've just put, with the one change that Alderman Savage suggested as recommendations to the City Council for approval of this ordinance as amended.
So Alderman Savage, will you second the amendments as amended?
Yes, second.
Okay. Further discussion? Hearing none, all in favor of amendments 1 through 10, please say aye.
Aye.
Aye. Okay. And that takes us back to the original 0621 as amended. I'll entertain a motion.
I move we recommend favorably to the City Council ordinance 06-21 as with the 10 amendments that the committee has just approved.
Second.
Okay, further discussion? Hearing none. All in favor of 0621 as amended, please say aye.
Aye.
Aye. Okay, finally, that leaves us 49 minutes to deal with 01919.
Madam Chair, if I could just give Alderman Gay the section that he's seeking out about the limitations of powers is in Article 4, Section 2A, limitation on conduct of aldermen and alderwomen. So that's in Article 4, Section 2A of the city charter.
Thank you, Alderman. So, 1919, the committee has voted on 4 amendments, I believe, and Ms. Green, correct me if I'm wrong.
You're correct.
Or is it 4 or 5? I'm seeing 5 in our notes. Amendments 1 through 5, Rules Committee updated. Did we vote on those 5 amendments?
Yes.
Okay. Did we vote favorably on those 5 amendments?
Yes, ma'am.
Okay. So, Alderman Arnett, do you want to speak to amendments 6 through 15?
No.
Okay, then let's just go on to Dr. Nash and Mr. Johnson and Mr. Lyle. Hey, too late. You said no.
Well, you asked me if I wanted to. You didn't ask me if I would.
Okay. All right. Sorry. Speak, please.
So, well, I will speak to it in the following manner. I was more than willing, because this has been so protracted, to call it a day with the 5 amendments that we had passed and send this on to the city council. But we've all received an email from our colleague Alderman Savage saying that there are several of these amendments, 9 through 14, I believe it's through 14, that he would like us to go on to consider. On the other hand, I would point out that just a few hours ago, we received a 24-page missive from the Director of Planning and Zoning, I think in coordination with the Director of Public Works and Transportation Department. And the reason I said I don't know what to do at this point is we have an embarrassment of riches of things to consider. And I can tell you quite clearly, I have read the first half of the first of 24 pages of the work that we got from the department heads. And I'm totally unprepared to discuss that at this meeting. And I'm willing to go on with the amendments that have been submitted. I certainly have strong support from those amendments from the committee, the Eastport committee looking at traffic. So I'm at your will. And I see Alderman Savage has comments to make.
Well, this committee asked Directors Nash, Johnson, and Deputy Duwa to visit these and come back with recommendations to us. And I assume that's the 24-page document that you're referencing from Dr. Nash.
That's correct.
Okay. So I think it would only be appropriate that we have an opportunity to digest the work that they've done. I know it took several meetings on their behalf to come together with these recommendations. So I would hate for us to not seriously consider them. Okay, so that's where I'm coming from. Alderman Savage.
Thank you, Madam Chair. And yeah, I agree. I do think we need to have a chance to read those and to give them due consideration. I did take a quick look, but I do think I think we're kind of talking about possibly 2 different things, because it looked like what they proposed was more of a different approach to our overall transportation APF, transportation standards. Whereas I think what Alderman Arnett is trying to accomplish with this are just tweaks to our existing traffic APF, not the overall transportation. Because the transportation looks like took into consideration pedestrian traffic and bike APF, which again, I think is great. But I do think that what they sent out, I think, and just based on my quick look through, is going to take a lot more deliberation, and we'd have to probably draft brand new legislation to accomplish that. So I think I do think we should move forward with that, but I also think that we should move forward with 1919 and just I think we're on the verge of getting something we can just pass to address some of these immediate concerns that Alderman Burnett has spoken to previously. But I do think regarding the amendments, I think there are a number we don't need to worry about, but there were some that I think are important to bring up just so we're consistent throughout, because there are a couple numbers that we didn't change, which again would need to get changed just for consistency. So if whenever you think would be the time, Madam Chair, I could get into some of the amendments just to explain my thinking on those.
Alderman Arnett.
So I am more than willing to pursue the amendments, but I guess I would like, with your permission, Madam Chair, to direct some questions to Dr. Nash and Mr. Johnson. I don't see transportation here, but I'm trying to figure out the nature of the document you sent. It doesn't look like it's drafted in the form of an ordinance. So I'm perceiving it to be supplemental information, and I'm curious as to how you would want us to view this document. It's obviously a lot of labor went into it, and I'm trying to figure out what we would do with this.
Dr. Nash, can you or Mr. Johnson speak to?
Right. So we started meeting, the three of us, and we kept coming back to the issue of certain things with the proposed ordinance didn't seem workable to us, especially certain things that weren't well defined and kind of would leave us in the same boat we're currently in, which is not really getting what we want out of these studies. And so we did maybe go a little overboard, and but I did include a proposed ordinance at the back. But what this is it's sort of an executive summary to explain our thinking, and then some guidelines to replace our existing guidelines, and then the existing legislation and proposed legislation. So, that's kind of where we arrived, because we were hearing that there was interest in there being more focus on safety. And so we kind of got stuck saying, how do we measure that? How would we show that? And so that was really the genesis of this, is that we want some kind of reliable metrics to measure safety, and then to be able to evaluate sites for safety conditions. So that's how we came to this two-tiered approach, where the first tier, you evaluate the project for safety, and then the second tier is a more in-depth analysis depending on the results of the first tier.
Dr. Nash, you said there's language, and I assume you're referring to Appendix 3. That would be page, 23, maybe 22 in the document. So that would be language that you would consider suitable for as amendment to this ordinance?
Right. I'm not sure if it could be an amendment at this point, because I've added in another section of the code, or if it would have to be a new ordinance. But I think this is kind of the direction we would like to head for this legislation, if possible.
Alderman Arnett, I thought your intent was to withdraw your amendments pending what the committee came back with. Am I misspeaking?
You are partially correct. My intent was to not move deeper into the amendments. And my read of the council and going to other committees was that these 14 amendments were quite dense and opaque, and I think that we need to change what's in the current APF because this traffic, which is currently labeled traffic, is not in the format of the rest of the adequate public facility legislation. That's what Teresa Sutherland saw, and I think she was correct. And that's why I agreed to submitting the current form of 1919 as a new version of the legislation to put it in the same format as the rest of the legislation. And I was fully intending to come to this meeting saying, let's stop before we kill again and just do the 5 amendments we have agreement on. I will pay a price with my constituents because they are strongly wed to some of the further amendments as we go on through the 14. But I was willing to say, let's get this in the right format with the few amendments we've made, maybe a couple of clarifying things. Alderman Savage pointed out, some places we say 400 feet, some places we say 250. Get that cleaned up, get that passed. I was not prepared to receive the document that we got today, and I haven't had a chance to read it, but I do accept that our senior staff took to heart what we asked them to do, and I suspect there's a lot of merit in it. What I'm seeing so far in my quick scan is this almost feels like regulations that go underneath the code on how we actually operationalize looking at the adequacy for automotive transit. And I know that Dr. Nash, you and Joelle Braithwaite have been looking at this same kind of thing for all the other APF too. And I think it's needed. I think APF, quite frankly, is long gone largely ignored by the staff because it was so hard to figure out how to implement it and have a set of criteria. And I accept that criticism. And I think that we now have many years of APF legislation and a few rounds of appeals of APF legislation that have told us that the original legislation was not clear. So personally, I'm comfortable with stopping where we are and just moving forward with the legislation with the 5 amendments, recognizing both that there is more work that the community wants us to do and more work that the departments want us to do. And I think we need to take the time to figure that all out. However, my colleague, Alderman Savage, who I think is a co-sponsor on this legislation, maybe not, and maybe he'll never be, but anyway, came back and said, no, we're throwing out some good stuff. So at this point in this meeting, I'm not really have much stomach for digging into slogging through amendments 6 through 14, and particularly not without having had an evaluation of what Dr. Nash and Mr. Johnson have done for us. So I'm of 2 minds. Let's just call a halt, recommend to the council 1919 with the first 5 amendments. I could live with that, but I'm not sure that that's how you feel, Alderman Savage. So I will turn this over to you.
Alderman Savage.
Thank you, Madam Chair. Yeah, so at the minimum, I would suggest we entertain amendments 9 and 10 because those would change 2 sections where to make it consistent, so one of our previous amendments from the last meeting changed it from 250 to 200 feet. In terms of the threshold for what projects we need to when projects we need to do this study. So 9 and 10 would make that consistent by changing, I think it lists 250 in the one place and then 400 in the other. And I think we need to change both of those to 200 to be consistent. Those I think are just kind of needed to be in line with our previous amendments. The other issues, I respect to the primary sponsor. I think I am a co-sponsor on this, but the primary sponsor, if you want to move forward without some of the other changes, but I'd recommend at least those two. But I will, if the other amendments aren't considered, I'll most likely introduce these as separate legislation, because just to explain it to folks, some of the other amendments, in particular 11 and 12, 11 would require that the traffic analysis has to take into consideration other nearby projects. And I know staff already requires that, but I think there's a benefit to having, hopefully even a benefit to them to having that in the code. And then the other amendment 12 would allow that. Let's see, the 12 I'm looking at. I'm sorry, 13 would allow for joint mitigation projects. And that was just the idea I had in terms of rather than having one particular project foot the bill on a mitigation project, having a number of them come together to be able to fund potentially a larger mitigation project that would get whatever the intersection up to a passing level. So I'm not sure there's that ability currently in the code. But again, if those require more discussion, I'm happy to just wait. The other thing was just an amendment that would, because currently, and again, one of the things that's different from the other standards in the APF, like Alderman Arnett mentioned, is that there are no consequences in the traffic APF. If a study says that an intersection is going to be failing after the development's built, they still get their certificate of APF, the way this is worded. Or for example, if there's an instance where there's no mitigation possible, or the mitigation would be insufficient to make up for all their trips generated, they still get the certificate of adequate public facility. At least with schools, if the schools have no capacity, there's a waiting list. So I think in this case, again, I'll wait on this if the primary sponsor wants to do that, but my intention was to have it be so they only get the certificate of adequate public facility if they can bring the appropriate intersection back up to a passing level, or if they completely mitigate all of their trips generated. So in that case, even if this intersection still would be failing, as long as they mitigate all of their trips and are not adding any to that failing intersection, they could still get their certificate of APF. But those are kind of my concerns with how the code is currently written for that section. But again, all that said, I at least think we should do those two amendments, 9 and 10.
Well, I've heard from both of my colleagues. I would prefer that, one, either we postpone this action, period, until we've had an opportunity to digest what the directors have provided to us, as we have asked them to do. If you insist that we approve some legislation this evening, then I would agree that it would be with the 5 amendments that we have already approved. But I would first want to hear from the directors on the impact of those 5 amendments. But my first desire would be to postpone this and not do it piecemeal. So directors Nash and Johnson, are you prepared to speak to amendments 1 through 5? Or was that included in your report?
Well, unless Mike wants to chime in, I think for 5, we addressed it, the pedestrian area, by defining a level of service for pedestrians, because we thought high pedestrian areas was kind of vague. I'm not sure where we ended up with 4. What number did we end up with for number of trips? Maybe Takia knows.
It was 200.
Yeah, I was going to say, I think it was 200.
200. So,
Oh, okay. I mean, I think I can live with that. Amendment 3, I don't know how public input would work exactly. This is, a technical document. I think what we've proposed, we could probably have a way for the developer to get input from the community on the safety assessments and their perceptions of safety. So maybe I can kind of adapt what I've done to implement this. And then Amendment 2, I think that, and Amendment 1 I don't have any issues with.
So I would entertain then a motion to approve O1919 with the 5 amendments that the committee has approved or gave favorable recommendations for.
So moved.
Second.
Okay. Is further discussion?
I do think that Amendment 4 is the one that changed the 200. I think it really needs to be, that's on page 2. I think that also shows up on page 3 on line 8. So that probably would also get cleaned up and be changed to 200. Although I would say that the standards are speaking to something that's different than applicability. For the sake of consistency, I think that needs to be done. But I agree with you, Madam Chair. I really do want to have the time to digest what the directors have done. And I do sense that these really are the things below the code. The code expresses, in my view, the intention to have adequate public facilities for auto transit. And again, skimming at the things that I think Dr. Nash has clearly, and Mr. Johnson clearly been grappling with, is how do we actually implement that? And I welcome that. I think that's important. And I think really the criterion standards are what are missing throughout the APF and make it hard to actually put in place and make work. So like Alderman Savage, I don't think our work is done with this. I think we need to come back, and I would certainly like to come back with him and do more legislation that probably will incorporate a lot of the work that we received today, but I'd see that as a different piece of legislation, a different amendment. So I'm comfortable with moving this forward. It's only been in process for 2 years now, as the number 1919 kind of indicates. And I think it leaves the door open to go ahead further and accommodate. And Dr. Nash, I would really turn to you specifically. How much of what you see and what you gave us today could actually be more in the form of a regulation or a process as opposed to part of code? I mean, part of what I think Mr. Lyles and Mr. Braithwaite have been saying is the code is too prescriptive and really, in some senses, too confining, and in other ways, too ambiguous for staff to actually implement. So I think if we do the 5 amendments and maybe an editorial cleanup, we are maybe more at the 40,000 foot level where code should be, and the actual implementation and the criterion standards that you use to make this work really are at the regulation level. And I see Mr. Lyles has rejoined us, and I would certainly want to test this with him as well. I don't think that we are qualified even, but certainly want to get in to micromanaging prescription of step-by-step things. I do think, though, that we want those things done. And so I think there's more room to move forward and approve all the APF language.
I would say this is the kind of the other case where we use these guidelines that are adopted by reference in the code. So we can't change them without a code amendment, but the language itself is not in the code. That's kind of what I was imagining, just because that's how we do it now. But we could make them follow the new process for regulations as well.
I'm sorry, I was on mute. Mr. Lyles, could you address, I think, the question that Mr. Alderman Arnett had about the legal reference, I guess?
Yeah, Joel had more touch on this, but basically our research with adequate public facilities and the council's desires here is that adequate public facilities is never meant to stop development. Adequate public facilities is supposed to be one measure with which a legislative body can ensure that there is development that accompanies appropriate growth at appropriate times in an appropriate place. What has happened with the level of detail and confusion and lack of clarity in the code, it basically stops development. And for us, that's probably not the desire here, but that's what's happened. So the level of detail that you get into at the code level does inhibit growth. City, town that does not grow is one that dies, right? So you got to have people come in. When they come in, they got to have a place to live, work, and play or recreate. And APF is supposed to be just one factor, not the only factor. But what has happened is it has become the major factor that has inhibited approval of all kinds of development, residential and commercial, because of the lack of clarity and maybe some of the detail that is taken away from the experts and put in the hands of, others.
Politicians?
Not politicians, because politicians, you direct it, but the system has been perverted from one that requires adherence to some guidelines to one that if the guideline is treated like a hard and fast rule, and that often means that nothing happens.
Alderman Gay.
If their questions are in relation to the discussion, I will, defer to another time because I have another comment.
Okay, Alderman Savage and then Alderman Arnett.
Yeah, I mean, I'm not sure I agree, Mr. City Attorney. I agree in the sense that APF's not out to stop development, but I think the problem is if you can't bring infrastructure up to an adequate level, then yeah, I think the conclusion is then that the development can't happen. At least, but I think really that's ultimately a policy decision. Because if the council decides, well, clearly we have, because some of our APF does say development has to get put on a waiting list until we do have the adequate infrastructure. And then others, like the traffic, says, well, it doesn't matter what happens, no matter what you do, you can still build, essentially. And even if the study says everything's going to be failing, and that's where I think my constituents want to, and myself too, wants to set a clear standard that the APF is that yes, if we can't get to a point with adequate infrastructure, that my constituents don't want to be seeing development get pushed through, because they don't want to deal with failing roads, failing schools, failing environment, no open space, and that's the problem. That's the thing you would have, because I also don't agree that a city that fails to grow is one that dies. I think there are multiple ways to grow, be it redevelopment, be it improving what you have. But I think we kind of digress to a certain degree here, because I do think, we have a motion we can move forward with.
So,
Alderman Arnett?
So I subscribe to what Alderman Savage just said, and City Attorney Lyles I think whether a city grows or not, it really is a policy question, not a legal question. And I do have some fundamental discussion points and fears about some things. And Dr. Nash, you know, that's also part of some of my angst with some of the goals in the comp plan as well. But I do agree with City Attorney Lyles that APF is not a vehicle to stop development. It is a vehicle to assure that adequate public facilities are there before you do the development. And the mitigation section of the APF, which we're only now experiencing, is that place where when you cannot do a specific facility standard, you come up with alternatives that are meant to mitigate not having that. And I think that's been the underlying theme with the Board of Appeals things is, are the mitigations equal to the services that are foregone? And so far, the Board of Appeals has said, no, they're not. And even in my discussions with Joel on like recreation, where they've taken the pay in lieu, and Joel has publicly admitted that they're not adequate substitutes for the intent of that in the APF legislation. So I think there's more work to be done on the mitigation side. I also agree with Dr. Nash and Mr. Johnson that the standards have to be made clearer for everybody. It has to be made clear for the people who want to do development in the city. It has to be made clear for the staff that have to process the applications. And I agree with Alderman Savage. If we know we have development going in a place where we already know there are failing traffic systems, we can't just go ahead and approve the project and say, oh, well, it's failing now and it'll only be failing worse. That's not providing adequate public facilities. And I think that's very antithetical to the very purpose. I do think that we need to be giving more thought to impact fees as opposed to mitigation, and copy things that the county and other areas in the state have done. And those are much more substantial than the mitigations that we've been talking about so far. But the developers always have the opportunity to wait 6 years and go forward with the project on impact fees. So don't pay it, just wait 6 years. I'm not sure that's going to make the residents particularly happy, but I'm not sure they're happy right now either. So, but anyway, I think we're far afield from discussing the motion, which is to accept the 5 amendments and recommend this ordinance to the City Council.
Thank you, Alderman Gay.
Thank you, Madam Chair, and thanks to the committee for allowing me to speak. I actually agree with the city attorney, and you know, that was when I was sitting here. That was my first thought. That's why I was allowing the conversation to take place. The adequate public facilities, auto transportation facilities, doesn't even mention anything about transportation or the actual most important infrastructure, that, you know, our actual transportation infrastructure. And so I think this doesn't even fix the problem, because the key is if you want to allow for development without an influx of additional vehicles on the streets and stuff, you have to provide adequate transportation for people. And so this is just saying do a test and then it'll tell me how many more cars can come through. Not I will actually sit down, take the time to take into account what we need to invest into transportation in order to provide for additional density and growth in the city. And so when I look at this, I do think that this is a form of a development stopping piece of legislation, because as you've noted, we don't have the space. Our infrastructure is failing. So every time you run the test at every intersection, it'll fail. I forget which report it was I was reading a while ago. I think it's the Eastport Forest Director Forest Drive sector or whatever, and they did the intersection study, and like every single one in the city was failing. And so this would not even fix that problem. And so I think it's concerning because we are limiting ourselves in regards to growth because we are concerned about the problems that it will bring to our infrastructure, but we're not actually taking the time to invest in the infrastructure or to do actual research into what we need to do to get to a point where the infrastructure could be sustainable for development. I don't know. I think we're going in the wrong direction, but that's just my personal opinion, and I'm not on this committee.
But Alderman Gay, you are a sponsor on this legislation.
I'm going to remove myself because I likely won't vote for it. I'm literally hearing this.
I didn't say that for that reason, but I just wanted to remind you that you are. Alderman Arnett, and we are down to 13
I know, and I'll be very quick. I actually totally subscribe to what Alderman Gay just said. This doesn't address transit and other mobility issues. It was never intended to address those. It started off as traffic. If you read the current code, it's how you do traffic studies. And it's kind of morphed into automotive transit, which refers to all kinds of private vehicle transit, but it does not address the very things you said. And I think that we do need to address those. And I think that those are the things that are going to come into play when we start talking about more dense development, like Long Forest Drive, or the things that are being discussed in the comprehensive plan as goals. And getting alternative modes of mobility is, I think, a whole nother piece of adequate public facility legislation that needs to be considered. So I don't disagree with you at all, but I will state I don't think that's the purpose of this legislation. What you want to do is outside of this legislation, in my view.
Thank you,
Dr. Nash doesn't agree.
Dr. Nash and then Mr. Johnson.
I just wanted to say that is what we did with the 24-page thing I sent today, and I sent it to you as well. We've combined all the transportation into one so that you have to look at it all comprehensively. And if there's a deficit in the bike system or if there's a deficit in the transit system, we also evaluate those in a two-tiered approach. So we can look at what are the safety of these systems and then how can they be improved and looking at it more comprehensively. So I propose to combine those two chapters of APF, the one for cars and the one for non-automobile, into one chapter and call it just the transportation systems and look at it that way. So we can always discuss that as a separate piece of legislation.
Right.
Thank you, Dr. Nash. Mr. Johnson.
Thank you, Madam Chair. I think that something has to be recognized in every city is that some intersections are what I would call constrained in terms of the ability to improve the level of service. Like if you take, if you go along, say, Forest Drive, that's like a county road, but there's no real estate to sort of expand those intersections. So I think that our thinking when we were looking at it, and Sally sort of, laid it out quite well, is that the only way in which we could sort of address those sorts of unpleasant situations is through some form of mitigation to other modes of travel. And the other modes of travel could include hiker-biker trails where you incentivize, cyclists, where you incentivize walking by sort of making improvements, and possibly bus transit where you disincentivize cars or incentivize use of that. You may not physically be able to improve an intersection because the city is an older city, it's well built, and there's really no physical way in which to do that. And I think that what we attempted to do is to come up with a document that sort of gives us something that didn't appear to be in the existing legislation, which was sort of like a rational basis for making those decisions. So you have at least a metric or a toolkit of metrics that you can use to judge every single project according to a standard, which didn't really seem to be easy to do under the existing structure that we had. So I would just add that it's, I don't think that it's that it's a pejorative towards bus transit or anything like that, as Sally mentioned, as Dr. Nash mentioned. It is included, through your mitigation efforts, you can accommodate other modes of travel.
Well, it definitely sounds like the report is something that's going to take us to another level as far as transportation in the city is concerned. And I look forward to our committee maybe being the ones who can step up and work with you to sponsor this, these significant changes that I've been kind of skimming through. In the interim, we have a motion on the floor to approve amendments 1 through 5 of 1919. It's been moved and properly seconded. Hearing no further discussion in 7 minutes, I will call the question. All in favor, please say aye.
Aye.
Aye. Opposed? Abstentions? Alderman Savage, you're not voting at all in any capacity?
I thought I did. Sorry, am I muted? No.
Did you?
I did. I thought I said aye.
I'm sorry. I didn't hear him. I'm sorry. Did you say, okay. So it unanimously passed the Rules Committee. So a favorable recommendation will go to the full council with 5 amendments. And I think, Ms. Green, would you make the notation?
You're on mute.
Back on mute.
Have I been on mute the whole time?
No, you left off asking me to make the notation and then you went on mute.
Okay, to deal with the change from 50 to 200, wherever that occurs in the legislation, because it occurs in more than the one place that's delineated in Amendment 4. Okay. Any other, I'm sorry, Alderman Gay.
Thanks. I'm sorry. I know this is not even my committee, but I find it so interesting. I
You
just
still only have 6 minutes, even though it's not.
yeah. Just on this report quickly. So when I think of like transportation and the role of the director of transportation, I obviously have to go look at the city code because I'm sure it says something completely different. But I think of they're in charge of transportation, cars and all of that stuff. But when I read this, everything goes back to the director of planning and zoning. And so my question is that at what point does the director of transportation come into the conversation and a joint plan is put together? Because I think that your expertise in research and analysis is one thing, but to actually understand the infrastructure of the roads and the routes and the expertise of what may be the best, whatever for cars is another thing. And so I don't see that though overlapping here.
Right. Okay. Sorry.
Go ahead. No, you please.
Okay. So there's a long version and a short version of the answer to this question, but basically there have been ideas over different time periods to rearrange the transportation functions in the city. And that's actually how Kwaku ended up in transportation, because it used to be in planning and zoning. But over time, it has evolved so that planning and zoning is in charge of the traffic impact studies. I am more than happy to give that task to anyone else. But right now, that's how it has been traditionally. And it kind of makes sense because we oversee adequate public facilities in total, and we deal with development applications. Transportation, really, after a series of staffing cuts in 2009, it was hard for them to keep up with anything beyond transit. The transit part of their operations is a big consumer of time. They do a lot of grants. They get all their money from the federal government. There is a lot of administration. There are a lot of legal issues. There's a lot of workforce issues. Like that consumes a lot of their time. So that's kind of how it has evolved over the years. I've put in my proposed language in consultation with Public Works and Transportation because I couldn't make an APF finding on transportation without input from those departments. It wouldn't make sense. So I think it's important that the three departments act in unison in some capacity. I'm not married to that language. I'm not married to planning and zoning have anything to do with it. But that's sort of the medium time frame answer.
As I learned, you should have been the third city manager, because I mean, transportation, public works, planning and zoning. I mean, it's like it's an umbrella of those three things. And if the communication is, not constant, or if it's like a gear, if it's a cog in it, then it messes up. And so I get what the point of this 24 pages is. I'm only on 8 right now, and I'll continue to read through. But I'm just trying to get a better understanding of how we could help transportation, because in transit in general, because I think that's the key to a lot of our problems as it relates to development and our goals for density and stuff.
Alderman Gay, this committee recognized the three-legged stool that you're referring to. And that's why it was Dr. Nash, Mr. Johnson, and Dr. Duwa representing transportation, who we asked to go back and work together. And that 24-page report is a result of their work. So transportation has not been left out of it. He's just not with us today for this presentation, but he is the third person. Mr. Gordon sent his representative, and Dr. Duwa, as Dr. Nash said, was in planning. So he's got the benefit of planning and transportation. So we're very fortunate. Okay, 1 minute. Alderman Arnett,
I'm going to make a motion to adjourn, but before I do, I want to thank Dr. Nash for the comments she made at the Citizens Subcommittee and the Maritime Task Force. I fully subscribe to what you said, and I hope you have it written down and bottled it so when we get to legislation, because you were right on target. Madam Chair, I move we adjourn.
Second.
Thank you. Thank you, all of you. Thank you for your report. Thank you for your work with the committee. Thank you, Alderman Gay, for joining us and sticking with us. Thank you, all department heads. Have a good one. And Julian, right on the money, 5 o'clock exactly. Thank you, Takia.
Thank you.
Thank you guys.
Meeting's adjourned.